Thank you.
Are you stressed at this?
He likes to sit over there.
Ori, on this RBT, have they given us sort of an estimate? I see the hourly rate, but an estimate as to what the package is gonna kind of run us?
Well, I was gonna get my jacket and get my thing, and you don't have a spare.
You can go get it. You got 5 minutes.
Does he want?
Just left this packet on the table.
No, I left my, yeah. Thank you. Oh, my pen, in my coat.
You really are the most annoying creature on the face of the planet, I swear to God.
I know. Almost.
Don't you, oh, you have one? Almost?
Well, I can think of more.
So
Hey,
back
Ben.
to John.
I'm sorry, what was it?
I was saying, have they given us some kind of estimate? It's pretty much,
They never really give us an estimate, but it's about the same that they do every year. They're usually coming around,
Hi.
say $7,000 or $8,000 every
Good
year.
format.
Same
Becky Allen?
Yes.
Oh, all right.
it's the same
That's
company we've been
okay.
using
Yes.
over and over.
I think it was 30 years ago.
Okay. Dover.
No? City attorney for Beacon?
Yes.
That's when it was.
Okay.
I had clients who had, they were kind of like slumlords. Big apartment buildings.
Name.
My client?
Yeah.
Silverman and Moss.
We've seen it, we've
Okay.
never met them.
No,
Where in Beacon?
I don't remember.
Okay.
That I don't remember.
What was the issue?
Building code violations, safety violations.
Okay.
I forget if they were rented or if they were.
Different than
That's-
us.
that's- I can't believe I was thinking about it driving over here.
Oh, yeah.
Surprised I can remember the names.
Yeah, that's pretty good.
I know you've seen
That's
it.
pretty good.
But that's it, no other details.
You know, we were very proactive on code enforcement.
Mhm.
Oh, I was thinking, how did you, oh.
That was the, I was like,
Oh, that's right, that's
This is
right.
not good.
I forgot.
It's like a back.
Oh, yeah.
And one of the issues was the letter didn't go.
Mhm.
And one of the,
Well,
in fact,
they're
just got
just
told
told.
one of the council members.
We get to that
That's his
point.
colossal letter.
Mhm.
But, they were all using the same conference call number.
Because if we don't get our own council member, who's gonna come and invest in the city?
Exactly.
Welcome and thank you for choosing freeconferencecall.com. You're helping people around the world communicate for free. Please enter your access code.
On Main Street, across from the Housing Center.
Oh, really?
If you are the host, press star now.
As a matter of fact.
Please
Yeah.
enter
Yeah, fewer,
your
but
PIN.
yeah.
Yeah.
That's one of them.
I was a friend of mine.
Thank
Yeah.
you. You are the
Yeah.
only participants in the conference.
I guess I moved it.
In fact, I ran into Ronnie Tech.
Well, it's not 7 yet.
Oh, she looks great.
It was really nice people.
Oh, yeah, I talked her into running for the city council,
Oh, did she?
and she won. Well,
She's on the board now?
No, this
Oh.
this is early nineties.
Oh, oh.
Early nineties.
Okay.
Yeah. I lived for the first time. And, after the mayor, served 15 years, 95 years old, she's still, not mayor obviously, but she's still kicking and got it up here.
Yeah, yeah, that's great.
Yeah, it's quite a story.
Mhm.
You can turn around.
Oh, yeah. Oh, yeah. It's a great place.
Yeah.
Too many people from Brooklyn.
Well, that's true too. That's what happened, is changing the entire tenor.
Yeah.
of the city. Just one building on Main Street.
You run back to the office to your minute.
Oh, okay.
And Fred Allen going to his insurance guy.
He was trying to get your attention.
Are they ready for us? Dave?
What's that?
Are they ready for us?
No, we're gonna go afterwards. It's a pretty
Oh,
short
haven't
agenda.
even started
It's a pretty
the
short
meeting.
agenda.
Oh, okay.
Yeah.
Yeah, sorry.
They sold the building to someone without, taking out all the
Well, just hang it up.
the floor.
They don't stay up.
Guy,
Mhm.
the.
That's not a good one,
The
here,
entire.
Yeah, I think Jennifer who gives it.
You see what happens, you
Yeah.
become Scarsdale, you become Scarsdale.
The problem is you drink them.
It's kind of sad.
Oh, it is.
Yeah, it is.
Yeah, it's like,
Oh,
wow.
okay. You still live?
Yeah.
Oh, interesting.
And then you slowly.
That goes back to my great grandfather.
Oh, wow.
Not only was
Yeah.
that,
Near the bridge.
Oh, yeah, remember from the sewer meeting,
Hudson
the back
River.
is funky on that
Yeah.
one. Yeah, that's
And
what
it
I
goes
had
down.
trouble with.
Okay.
Let me look at those.
Yeah,
And we still
They should
need
be
to,
adjustable.
we still need
It's
to
got good back.
do these
Yeah,
wires.
it's nice to
Yeah.
live in a city where you
Well,
spend a lot of time professional.
Yes.
Now,
All right, good evening, everybody. Welcome to our January 17th, 2023 Village Board meeting. Can you please join me in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Just don't want to monkey that.
maybe there the whole time.
No, it's something we use just.
Huh?
This is the one that goes. All right, so did everybody have a chance to read the minutes?
Yes.
All right, can someone make a motion to accept the minutes, please?
Somebody.
I'll second.
All in favor, say aye.
Aye.
Everybody have a chance to review the RBT CPA's proposal to us. This is an annual proposal. This is a company we've been with for years now. They fall roughly somewhere between $7,000 and $8,000 a year. It fluctuates a little every year as far as how many hours are spent. Does anybody have any questions regarding the proposal?
No.
No.
Okay, so can I entertain a motion to approve it?
So moved.
Have a second?
I'll second.
All in favor, say aye.
Aye.
All right, so the next item is the new building department fees. Some of this is as a follow-up from last month when we had to make changes to 10A due to meeting the state requirements. And then this is also, we have now just completely updated the building department as a whole. And we've added in quite a few annual inspections that were not being met for quite a few years. So we are now bringing that up into compliance. So these fees are reflecting those changes. Does anybody have any questions regarding the new fee schedule?
No.
Now, what's the next step for this?
So we already have the new permit out, and we are now going to be starting to schedule some of these inspections that need to happen. We also have some follow-up inspections that have to occur from our I&I study that we did, where we found some issues, and so now the building department will follow up on those and making those corrections.
Very good.
So, all right, so can I entertain a motion to approve the new fee schedule?
So moved.
Do I have a second?
Second.
All in favor, say aye.
Aye.
And we don't have Dan Stone? All right, well, the one thing that I can update us on is that I'm happy to report in the fact that we received the permits necessary to move forward with Lower Baxter with the wells. So I do know that Dan wanted to talk about a few next steps. I'm not sure why
You
he's,
can call him and try him. Sometimes he has a hard time getting it. I don't know why. Maybe.
I would have thought he would have texted one of us.
I don't have anything.
Bear with us a minute.
Yeah, in fact, it's a Tuesday night, so you might have thrown off the schedule.
It's true. But he was on our
Yeah.
One was
call
on.
this morning.
Oh, okay.
Crickets.
All right, let's move on.
Okay.
I think then we're done. Dave, do you have anything that we need to discuss
No.
before we move
No.
forward?
Nope.
Okay. All right, so I guess we want to move into the hearing.
So, I'm gonna start with, well, I'll let you start, Pete. I've got people, this went faster than I thought, so some of the folks who are gonna be witnesses are
Oh,
gonna be here in a couple minutes.
okay, well,
So Rob is
Rob's on his way.
But I think you probably have some.
Yeah.
We thought we might have some call-ins, but nobody's on.
Yeah, you should have some soon.
I wanted to begin by introducing myself to all of you.
Behind you, sorry.
I am a recently retired county court judge here in Dutchess County. I served in 3 different courts for 20 years in Dutchess. I was elected in 1999 as a family court judge. I served 1 term there and then was elected to county court, which is a criminal court, handles all our felonies, murder, robbery, everything under the sun. And at the same time, I was served as an acting Supreme Court justice. Acting Supreme Court justices have civil jurisdiction, and one of the beauties of the job that I had was, while I was also handling the most severe criminal cases, I was also handling every type of civil case under the sun. I tried medical malpractice trials, negligence cases, contract cases, anything that come in as a Supreme Court justice. I did that for the time that I was also family court and county court. Kind of had two hats at the same time. And on top of that, I was acting surrogate too, whenever the surrogate had a conflict. So since 2020, when I retired, I have been serving as of counsel as a mediator and arbitrator in the Hudson Valley area. Prior to becoming a judge, I started my career as an assistant district attorney here in Dutchess County, trying cases for the district attorney, who at that time was Jack King, later Bill Grady. And I was a town attorney and a city attorney for the town of Dover, town of Pleasant Valley, and the city of Beacon. I am a native Beaconite, lived in Beacon all my life, and had the privilege of serving as city attorney from 1990 until my election to family court in 1999. And I felt that I covered a lot of municipal law areas as the city attorney. I also was the attorney for the planning board and the zoning board of appeals in Beacon, went to all their meetings. And likewise with the town of Dover, I was the town attorney and also consulted with the planning board and zoning board of appeals. I probably served in the town of Dover for about 10 years. Both of those positions were part-time. So I was at that time in a firm named Quartararo & Quartararo when I was in Dover, and later I was partners with Jerry Pizzinelli before my election to family court. So I bring to my role as a hearing officer, I think a wealth of experience. As a Supreme Court judge, I would oftentimes have to rule in matters that involve municipalities, Article 78 proceedings. I handle those types of cases. I also wanted to let you know that since my appointment by you as a hearing officer in this case, I've had a chance to review the local law that sets up this hearing, local law number 3 for the year 2022 that you folks adopted back in 2022. I traveled to this village hall, I think it was last week, to go over the invoices that have been submitted by council, by the architect, as well as your planner. I highlighted those invoices to Vivian and asked her to submit those to all the attorneys, which she did. I've also reviewed the case law that council have determined that is relevant, so that I'm up to speed on the case law in this area. I also reviewed the decision in Supreme Court that I'm sure you're familiar with from Judge D'Alessio. I've also reviewed the report from Robert Orr and Associates, and I presided over 2 Zoom conferences with council as we got ready for tonight's hearing. So willing to entertain any questions that you may have for me background-wise. Want to give you an idea of what I've done in the past before I came to this position in 2021, and I'm ready to, basically what I'm gonna do in this is synthesize the factual evidence that comes before you tonight. I'm gonna then give you a report as to my recommendations as to how you should proceed. You are free to accept the recommendations that I make to you or reject them. You're hearing the same thing I'm hearing tonight, but as a hearing officer, I think my charge is to take the law and to apply that law to what I hear and to make a recommendation to you as a board. And then I expect to be able to get a report to you within 10 days. Okay?
Sounds good.
Thank you.
Thank you.
I want to thank the mayor for giving me the ability to come in on short notice to go over those invoices and to work with Vivian, who was very helpful in getting everything out to the attorneys very quickly. So I appreciate that. Appreciate your courtesies. Thank you.
Thank you.
I think the first step is procedurally, we've talked in our Zoom conferences, who goes first. I don't think it really makes that much of a difference, but if you.
There's my witness.
Okay, if you wanted to proceed, Dave, you can go right ahead.
Why don't you're gonna be, why don't you be first? And you want us over here, Judge?
Sure, that looks good. You want to move that out to the room?
Good evening, I'm Dave Daniels, the village attorney, and I'm here to present the information to the board and to the hearing officer special counsel regarding the fees that have been assessed and charged in connection with the 146 Main Street application for modification. And we're going to start with Rob Fisser, who is the chairman of the planning board. Rob is under the local law number 3, as you all know, is the reviewer. So Rob, I'll let you.
Sure. I'm Rob Fisser, chairman of the planning board.
Yeah, you can back here while I'll switch with you when you're done.
So as I understand it, they're contesting pretty much all of the fees, is that right? The planning attorney's fees?
Yes.
So in the whole. So we did quite a bit of research as far as, what's just as far as the fees that have been charged so far. I'll start with planning. So our planning fees from our previous planner have gone down 22% from our previous planner. And looking at other municipalities, as we have started from the very beginning of when local law number 3 was enacted, we're perfectly in line with what a lot of other municipalities charge for those engineering and planning fees. Robert Orsby, the village architect that was assigned to this project, he came highly recommended. We knew this was an important project. We wanted to get someone who was familiar with, the work of Andres Dewaney and the comprehensive plan. We reached out to a couple of people, Nancy Tanner being one of them, who was, integral part of the original comprehensive plan. She reached out to Andres Dewaney's firm directly, and he came recommended from Mr. Dewaney's firm. So we thought he was a very good fit for what we needed for someone to review this project. Our attorney's fees, they haven't changed in 8 years for the village. And again, reaching out to other municipalities, he's in line with what other municipalities charge. I don't have much more else to say than that. We've done our homework. We feel like these fees were just. Have they accrued to an amount that the applicant's not comfortable with? Yes, but we've had a project that hasn't been pretty straightforward. We've had to go back and look at this project quite a few times, and we've needed professionals to help us through this process. So I just feel like we've done our due diligence, and we've made sure that the fees were appropriate.
I think if anyone on the board has any questions for Chairman Pfister, this would be an opportunity for you to ask those questions if you have any.
No,
I don't.
Everybody?
Not right now.
Thank you.
Take it something. Be right there.
Thank you.
Nobody's called in, right, at this point?
Nobody was calling in, so I turned
Waiting
it off
for,
because we had the
Robert
music.
Orr and Karen Bruto are both supposed to be. I sent them, I told them it was going faster than we thought, so hopefully they'll be soon. Okay, just to kind of touch on a couple of things that Rob talked about. The Robert Orr rates, he's at $2.50 an hour, and
Thank you for choosing free.
no, it's okay.
If you are the host, press star. Please enter your. Thank you. There is one other person in the conference.
Find out who that is now.
Hi. Say hello. Wait, to call this up. Hello?
Hi, Karen Lobruto.
Okay.
Hi, Karen, if you can just hold on, please.
So that was actually a good timing because, Karen, can you hear me?
Yes.
Okay, so we're just talking about the architect fees, and then we'll turn it over to you to talk about your fees as planner. The one thing I think Rob explained it pretty well. Robert Orr is really a protege of Duany. He went to Yale with him. They collaborate a lot. He talked to the Duany firm when he was doing this project, and I think he was uniquely qualified and situated to do this project. As you may recall, Frank Fish was sort of assisted Duany on the New York side in terms of the master plan and zoning back in 1990 through 94. Mr. Fish did a limited engagement for the village recently, and his rates were $290, so a bit higher than architect Robert Orr. So also well, I'll wait for Robert's he's going to be on the call, but I just want to hand out. Well, I will hand it to you, Judge, and then give Ben a copy as well. A couple of other things in here. There's an email from Ed Larkin. Oh, that's the other thing that. Sorry, Karen, I'm gonna jump in with one more thing. So when Rob was doing the assessment, he received an email from Ed Larkin, and Rob, do you want to talk about that a little bit?
Yeah, sorry, I forgot to mention
yeah.
that.
Yeah.
So I did get a letter from Ed Larkin just because we wanted some kind of baseline from him on, how they base their fees. So he wrote back a letter to me, and we'll give you guys a copy of this, but it says, "Dear Mr. Pfister, in connection with the Main Corners property application to the Village of Pawling Board for site plan modification for 146 East Main Street, we've been asked to provide our opinion as to reasonable and necessary amount to be placed in escrow to cover the professional fees that will be incurred by the village in connection with the Village Planning Board's review of the application. So in reviewing this request, we have relied on our extensive work performing professional consulting to municipalities across New York State. Our engineers and planning consultants have collectively been involved in hundreds of applications for municipal planning and zoning approvals in New York State over the course of many decades. The vast majority of professionals engaged in providing professional services for planning and zoning support work on an hourly basis, with an estimated total based on the complexity of the project. We engage in these services via open and competitive municipal bids. We've also reviewed the hourly rates being charged and/or proposed to be charged by professionals in our industry. In our opinion, our hourly rates are competitive with similar professional services in municipalities in the Hudson Valley and elsewhere in New York State. Further, we consider a reasonable and necessary fee to be one which is necessary to perform a municipal board's review. In support of carrying out its decision-making function with respect to a given application, this requires taking into consideration the size, type, and number of buildings or structures to be constructed, the topography of the site, environmental conditions at the site, the infrastructure proposed in the application, the project cost, and the overall complexity of the legal, engineering, planning, architectural, and other issues presented by the given application. The final variable that must be factored into determination of fee is the quality and completeness of an application. In accord with the Village of Pawling, Local Law Number 3 for year 2022, the village can request a reasonable and necessary fee. This fee must bear a reasonable relationship to the average fees paid for similar professional services by applicants in comparable land use approvals in the region. Based on the nature and scope of the application referenced above, we estimate that the reasonable and necessary fees associated with the application, including professional services incurred to date, is $13,000. In our opinion, this amount is also at or below the average fees paid for similar professional services in municipalities. Now, this was dated July 21st, 2022. So, again, there had been a lot of back and forth even since then about proposed changes to the project, you know, how they were gonna impact the project. There's been legal matters that have come up since then, so there's just been a lot that's gone on. So, I mean, at that date, that was a reasonable fee that, you know, that he had thought was gonna be, you know, needed for escrow at that time. Just to give you an idea of where we stood at that point in this project.
And then, before I turn it over to Karen, Rob talked a bit about the attorney's fees. The only thing I'll add is that I've been the village attorney since 1991, and I was very involved in the comprehensive planning process and the zoning process, including reviewing and substantially editing the comprehensive plan itself, and writing the zoning code in conjunction with Frank Fish. The other thing is, I mean, the bills that we laid out, they're itemized in the way that I always itemize my bills. I've been doing that for 40 years, and do I ever have questions come up? Sure. Do I address them, and usually to the satisfaction of the client? Yes. This was not a case where I was given the opportunity to do that, whatever issues there are, which I'm still not sure about. I imagine I'll hear some of that tonight, but, so that's the attorney's fee issue. And I also conferred with several attorneys in the area about rates, and I'm comfortable with our rates being within market. I'm happy that there's a hearing officer who I'm sure has decided many cases about fees, about rates, and you know, so that will be up to the board to decide in consultation with him. So Karen, do you want to talk a bit about the planning fees? I will tell you that Rob Pfister had already indicated that your rates are somewhat lower than the prior planner's rates, which were 175. I think yours are in the mid ones. You can clarify that.
Sure, could you let me know who is at this meeting?
Yeah, so we have the village board, and we have former Judge Peter Foreman, who's the hearing officer. We have Diana Tomasetti and her attorney Ben Gailey, and then there's four members of the audience, including Rob Pfister.
Okay. Got it. Okay, so yeah. I am charged out at $142 an hour. Since April of 2022, there have been 6 submissions. These were constituted by multiple revised renderings, EAF, otherwise known as environmental assessment forms, an amended site plan application, response to comments, response to Robert Orr's comments. And so as part of my review during this time since April, I have reviewed all of the materials that have come in. You know, looking at the renderings, I'm comparing them to what was submitted previously. I'm comparing them to, you know, what was shown previously and how it was related to and discussed in the SECR documentation. That's the State Environmental Quality Review Act. I'm considering it in context to other projects and how other projects are processed over time. My review looks at the environmental assessment form, which is a technical document that requires accuracy. In particular, it requires me to ensure that there's accuracy there. I'm looking at the fact that this is in the DEP watershed, and because of that, it has implications as to how it's analyzed by the State Historic Preservation Office under Section 1409. I'm looking at what all these changes could mean or how they might influence the secret documentation as it pertains to the use variance that was granted by the CPA. I'm considering the off-site improvements that were made, how they relate to the project site, whether they were permissible, how they relate to the use variance. I'm considering the area variances that were permitted and whether they have changed or are still valid. The time that's charged is also charged for meeting time. It's also charged for the time it takes me to write up my comments. And it's also charged for consultation with other contractors, consultants on the project.
Thank you, Karen.
Thank you, Karen.
My rate is, yeah, I was just gonna say that my rate is similar to other senior planning rates, as you've just heard. Apparently it's lower than their previous planner. And as someone that works on multiple proposals for both municipal projects and other private projects across the Hudson Valley, I have my eyes on billing rates all over the place, and I can tell you that mine are very consistent with those rates. Thank you.
Thank you, Karen.
Thanks, Karen. The only other person I have is Robert Orr, who I expect to call in any minute now. The only thing I'll add, Karen, just in terms of the legal fees, I mean, it's sort of hard to describe everything that went on, but as Rob had mentioned, there have been a number of fairly involved legal issues coming up in the context of seeker, which you know, have been contested by the applicant and has resulted in a great deal of back and forth, and still, as I understand it, we're still not in agreement on that particular issue, which you know, has generated the need for research and writing letters which were requested and the like, as well as the process itself, which has involved preparing a number of resolutions and notices and doing so in compliance with the technical requirements of seeker under a regulation that, you know, it's got a lot of moving pieces to it. So I'm gonna call Robert, see if Hey, Robert, are you gonna call in? Yeah, we're all ready for you. Yeah, no, things moved quicker than we thought, so we're ready for you now, okay? Yep, okay, thank you, bye.
Just in case he has trouble calling in, we can have him on your phone.
Sure, yeah.
Or we can
Yeah.
call him.
Yeah. You want me to let him give it a try, or was there?
I guess let him try. I mean, Karen's on, so I mean,
All
it's.
right, let me do that then. Hi, hey Robert, so you're on speaker, the call-in is not working very well, so you have the village board here, I think you've met a lot of them, and Judge Peter Foreman, who's the hearing officer, and we have the applicant, Diana Tomasetti, and her lawyer, Ben Gailey, here, and Rob Pfister, the planning board chair, and 3 other members of the community. So, and as you know, we're here tonight to talk about the work that you did for the planning board in connection with the 146 project. And I thought you could start by just talking a little bit about your background, and then maybe you can get into some of the details about your efforts on behalf of for the planning board. And I'm also going to be handing to the hearing officer and to the applicant's attorney a copy. You had provided some detail, but the applicant had requested some additional detail, which you prepared, and I am giving that to, and that's the itemized. I'll give a copy to the judge.
Dave, you want to put your phone by the mic there? That
Oh, sure, yeah.
might,
Yep.
people might be able to hear it better that way.
Okay, thank you. Yep. Okay, you're on, Robert, go ahead.
Did you say you wanted me to go?
Yeah, go ahead. Why don't you start, just talk a little bit about your background, and then you can get into the details of the work you did and the time it required.
Okay. My background is, I went to the Yale School of Architecture. I was sat next to Andreas Duani. By the way, it takes as long to become an architect as it does to become a doctor. I just realized tonight. But anyway, Andreas Duani, I know, did your plan, and we have worked together on numerous projects. We have done projects like your project in a number of communities, i.e. done comprehensive plans and zoning codes in a number of communities across the country. And my architectural experience after graduating was working for a number of architects, including Philip Johnson, you may have heard of, and Alan Greenberg, who is responsible for bringing back traditional architecture. Andreas called me. Actually, we communicate quite a bit, and actually I talked to him quite a bit about this project. But he called me to consult with the town, with the village, and thought that I would be well suited for it because of my background. So that's my background. We are an award-winning firm, 50 years experience, graduated in 1973 from architecture school. So we have a lot of background in these sort of things. So Dave asked me to show the detail of our billing, and so I put that together today, and I sent that to him, and he's printed out a copy of it. If you look at it, you'll see that the time, it's over a 3-month period, and the time billed is quite a bit higher than, quite a bit lower than the amount of time we put in, and that's because a lot of the time we put into the project was familiarizing ourselves with the comprehensive plan, et cetera, which we would have to do for any application. So we didn't bill for that. All pretty straightforward. What was, it seemed of concern to us was that, first of all, the comprehensive plan is very clear, and it was put together through a public process. And not only does it verbally describe the intentions of the village center, but it has renderings, images of what they mean by the words. And as the saying goes, a picture is worth 1,000 words. So that's the intent of the village was to keep the character that is so appealing to the village and have new projects feel as though they've always been there and contribute to the character of the village. So obviously, if we put a wild, put a Burger King right in the middle of town, or a Walmart, I think we could all agree that is not in the character of the historic village. If we put giant parking lots in the town, or parking garages, that's not in the character. So there are things that are obvious, and then it gets down to nuances, and something that is trying to be in the character, but doesn't quite make it. And I actually sit on a architectural review board for a town in Florida that meets once a month, and applicants have to come before the architectural review committee before they can go to the county to apply for their building permit. And so I've got a lot of experience in looking at projects and actually helping applicants, which in the case of my experience there, they look to us, project clients look to us to assist their architects or whatever to come up with better designs. Improve. I mean, not starting from scratch, but if you just move this window over a little bit,
Hey, Robert?
Yes?
Excuse me. I think you've made that point, and I think you've heard some of that stuff. Could you talk about this project in particular and how you applied that stuff to this project?
Yeah.
Yeah.
We looked at how the initial design fit with the context, the design that was approved, and we reviewed that, and met with the board over that. Then we actually came to the town, and after doing quite a bit of research before coming, to look at the project in situ, since it's partway built, and it clearly not only didn't meet the criteria of the village, didn't fit the character of the village, but it didn't reflect the design that was approved either. So we wrote our report that basically said that.
Robert, just a question. Can you hear me?
Yeah.
So
Yes, I can.
did the amount of work that you had to do depend to some degree on what you found in terms of those I guess you would call them deficiencies? And if so, could you explain that?
I'm sorry, could you explain what you're...
In other words, you started to talk about some of the issues with the design and kind of the nonconformity with the design.
Right.
Can you talk about that in terms of how that impacted the time that you had to spend on this project? If it did.
Because there were distinctly separate opinions, it came upon me to really examine this closely, to not just peruse over it and cast decisions, to really give it a chance, as it were, and to look at it closely. And that's why we came to the village and looked at it carefully. And what we decided was that not only was it failing in certain respects, but also it's a gateway project, which is to say that this is an important location that sets an example that future people will look to follow. And so it should be the aspiration of the applicant to really do something that will set the stage for work to come. And so I think it bears more responsibility in that regard. We went over that. We also said that the changes from the design didn't look like they saved any money. It was obvious that the applicant was putting a lot of attention into the building, and so it wouldn't have cost any more, or probably even cost less.
Hey, Robert, I'm gonna just cut you off there because we're kind of getting off point. This is only about, fees tonight, okay? With the substantive issues.
Another question.
What's that?
You asked me another question.
Yeah, but you answered it. That was good. Yeah.
Okay. Okay.
So, does anybody have any questions?
Can I ask a question?
Yeah.
Hey, Robert, this is Peter Foreman.
Mm-hmm.
Now, when I'm looking at your the breakdown of your time that is contained in the email dated earlier today, I'm also reviewing your report that was dated July 11th to the planning board.
Okay.
The time that you spent was, it looks to me, by looking at this breakdown, is that you indicate July 7th, you revised your letter to the planning board. I think you put down 2 hours. And is the June 28th time also contained in that, there's 4 hours, write findings to planning board. So would it be fair to say that you've got 6 hours in preparing this report that was dated July 11th?
Yes.
Is there any other time in that listing that would be applicable to that report?
Well, it all led up to the report.
Okay, so, and I don't want to put words in your mouth, but you're saying that other entries factor into that report because everything that you did on this project made its way into your final report to July 11th?
Right. You can see that most of our work was done in June.
Right.
And so that's when we were collecting the information, getting the feedback, et cetera, and then we put it all together. The work in July was not that much. It was, putting it all together and getting the report turned in, and then of course coming to the hearing in August.
Thank you.
I have some questions also.
Go ahead, Ben. This is Ben Gailey, Robert.
I'm
Okay.
sure. Yeah, this is the first time we've seen the, this detailed breakdown. We weren't provided this before. So do you have a copy handy with you?
Yes.
Okay, so let's just run down this, the details here. So back on May 5, you had a conference call for 1 hour.
Mm-hmm.
Who was that with?
The planning board.
You You had a call with the entire
This was
planning
at the very
board.
beginning when we were getting our marching orders, as it were.
Okay, the planning board was telling you what they wanted you to accomplish.
Yes.
Okay, and then on May 16, you had a conference call regarding public hearing for 1 hour.
Mhm.
And what was that
There would be a
about?
public hearing and how it would be structured and so on.
Okay, and who was that with?
Probably members of the planning board. I mean, most of our contact was with members of the planning board.
Okay. Was it like the entire board or what?
Sometimes.
Okay. And then on May 24, you had a conference call regarding tile roof investigations for 1 hour and 15 minutes. What was that about?
There was a lot of attention to the tile roof. And so we did some investigations to see how it might be interpreted favorably or not, and came to the conclusion that it really didn't fit the character of the town. And it also didn't conform with the drawings that were approved.
Okay, and in terms of not conforming with the drawings that were approved, you already had a letter from the town building inspector setting that forth, is that correct?
Yes.
Okay. Who was the conference call with concerning these tile roof investigations?
Well, it would have been, again, members of the planning board, perhaps the building inspector. I don't recall at this moment.
Okay. Then on May 26, you had a consultation, well, I don't know what it means here, IND period, COMP period, planning attorney, or plan attorney.
Yes, we consulted briefly with a expert attorney who deals with comprehensive plans, just to get some boundaries and so forth that we, to guide our work.
And who was that?
A local attorney in
Name?
Connecticut.
Pardon me?
Do you remember his name, sir?
Don Doig.
How do you spell the last name?
Doeg.
Thank you.
Okay, and then on June 7, the entry says, reframe project as gateway project. What does that mean?
That's when we realized what I just said,
Which is what?
that this is a gateway project.
Okay, and it took you an hour to make that realization?
Well, it apparently caused a number of things to happen. I don't know.
By the way, I can't help but notice that most of these entries are like whole numbers, 1.0, 3.0, some are 1.5 or 2.25.
Yeah, you would like it to break it down into more fractions?
No, I was just curious how you bill. You just bill by the quarter hour or what?
That's what it looks like.
Okay. So on June 12 and 14, there's 2 entries on the 14th actually. They all deal with work on the assessment with the design.
Yeah.
What is it?
Sometimes I was working at 7 o'clock in the morning and sometimes at 8 o'clock at night, so I put them both in.
Okay, and what does that mean, the assessment with design?
Just what it says, it's assessing the building with its own design. The design with the design of the building with the comp plan.
Okay, and then on the 15th, there was more time on that. So we're looking at, looks like 10 hours you spent doing that. Then in terms of writing the report, on June 16, you have an entry which says, write letter concerning 146 Main Street, and then on the 17th, revised letter. What, is that part of the report, or is that actually something separate from the report?
It probably was an early version of the report.
Okay.
And I'm gonna jump in for a second, Ben. I added up those hours from June. Oh, I'm sorry, take it back. Yep, go ahead.
Yeah, I added them up just very quickly when I was sitting here.
No, you're right.
And starting with that June 16
June
entry,
12.
when the report was begun to be written, I came up with just, like I said, just sitting there doing my head, I came up with 15 hours just on writing the report alone. Not any prep for the report or any assessments, just actually writing the report was 15 hours.
So if you're taking from June 16th until July 7th?
Not every entry, just the ones that refer to write letter, revised letter, or.
They were different letters. They were different letters. And there was a lot involved in writing a letter. It involves things that references, confirming that what you're writing about is accurate. You know, we do a first-class job. If you want a sloppy job, get somebody else.
So you wrote letters in addition to the report, is that what you're saying?
They probably were getting ready, you know, they were probably early versions of the letter that finally was turned in.
Okay, did you send any of those letters to the planning board or any to the village?
I may have talked about it with him.
Did you send those letters?
I'd have to go look at my emails. I mean, this is really humiliating. How much do you want me to do?
Well, I apologize for that, and I'm certainly not trying to humiliate you, and not in the least, as a matter of fact, and certainly
Well,
respect.
you're very insulting. This is a very insulting phone call.
Well, frankly, I found a bill of $10,000 to my client to be offensive,
I wasn't.
and that's
billing
why
your
we
client,
appealed that.
And it wasn't $10,000. As you can see, it's 25 hours.
Well, what your detail that you submitted here says the total time spent is 38.25, not counting the per diem time.
Mm-hmm.
And the per diem time, just, I assume the hearing officer is aware, but the board is aware, on the day of that Mr. Orr attended the planning board meeting, where he basically just repeated what was in his report that he already submitted. The per diem charge was $2,000. So simply to drive here and attend that meeting and then drive home, you know, we charged the village $2,000 just for that one day, which then was turned around and, you know, charged back to my client. And I'm not saying with respect to any of these charges, with respect to the legal fees, the architect or the planner, that they shouldn't be charged to the village. What I'm saying is they should not be charged back to the applicant. And
Well, that's not my problem.
oh, totally agree, completely agree. But
So why
where,
are we having a phone call?
yeah, the only thing that the village is allowed to charge back to the applicant are charges that are reasonable
Yeah, I
and
don't wanna
necessary.
hear about that.
Pardon me?
I don't really wanna hear about that, because I have no contract with the applicant.
Just
Okay,
like,
that's-
let me jump in. Mr. Orr?
Limited to my services for the town, period.
Mr. Orr, this is Judge Foreman again. We're having this hearing tonight pursuant to a local law that is in place that allows the applicant, if you will, to audit and to request the village board to change the amounts that have been forwarded to Mr. Gailey's client under the law. And under the law, he's entitled to make this type of a claim, and the village board has an obligation under the law to essentially give him the opportunity to go through these bills and make a determination as to whether his claim should be accepted, modified, or rejected. And they have appointed me as a hearing officer to try to synthesize all of the information that's been submitted to them and make a recommendation to them, which I'm going to do in writing.
All right, well, this was never laid out to me, explained to me. I have no information about it. We had an open-end contract with the town, and I'm happy to talk about that.
Well, and I think I speak.
I don't know what they're talking about.
I think that you've been very forthcoming, and you've given us a lot of detail to help us make the determinations that we're required to make under the law. We appreciate your patience, sir.
And I spent all day doing this. Thank you.
Ben?
Yeah, I don't think I had anything more for Mr. Orr.
I think this should be put on my bill.
Just don't charge it back to the applicant.
Thank you, Robert.
Thank you, Robert.
The village board appreciates your time and effort.
I have a question for Mr. Pfister also, if I may.
Sure.
Rob, you said you had checked with other municipalities. What did you check exactly?
So we called to see what a lot of the fees were that are charged by consultants. We found out that a lot of attorneys are either on the payroll or they are subcontracted, basically, like our attorney is. Also, the same with engineers. Some are in-house, some are also, a lot of those seem to be billed out independently.
So what information did you obtain from these phone calls?
That they ranged from, quite a bit, like Frank Fish's firm, which billed for engineering and consulting fees from $390 till I saw it down to the low end, $120. We've got
It's
attorney-
$290.
It was $290.
$290, did I say $390?
Yeah.
$290, sorry. Attorney's fees ranged anywhere from $150 upwards of $450, so there was quite the range.
And this is an attorney charge $450 an hour to a municipality?
For just general municipal law.
Who?
Who charges that?
Yeah.
I couldn't find that anywhere. That was a general search that I did for municipal lawyers, that I found that high-end number
Where's your search to find that?
on the internet. But I also
So
called
you're
some
saying that,
municipalities
you're
also.
saying that attorneys put their rates online?
No, not a specific attorney put their rates online.
What municipalities did you speak to?
East Fishkill, Peekskill. I talked to some attorneys in Poughkeepsie.
And when did you do this?
When?
Mhm.
It's probably about 2 months after the local law was passed, up until last week.
Okay.
I continuously looked at these things.
And did you?
I reached
make-
out to your firm, actually, also.
I heard that you called today, as a matter of fact.
Yours was the only one that wasn't very forthcoming with their rates.
Well, because we knew who you were.
Fair question.
Did you write any of this down?
I think I did. I wrote some of it down, sure.
What do you have? Do you have it there with you?
What would you like to know?
I don't know, we're not, that's attorney-client privilege, we're not gonna he had conversations with me about it. So,
Okay, so you're not going to
I
produce?
wanna review it first. Let me see what he got.
I just like jotted it down on another piece of paper that I had as far as, like they literally are just jotted down notes on here. Some of the municipalities that I talked to,
Yeah,
it's like.
we're gonna not disclose that, because we discussed that.
Okay.
So, yep.
What I'd like to do is, Judge, these are copies of the invoices that we've received more recently, either last week or the week before after you went to Village Hall.
Right.
I'd like to pass these out to all the board members.
Sure.
You have a copy of this already, correct?
The invoices?
Yeah.
Yes.
Yeah, okay.
Thank you.
And Dave, you have those, right?
I don't know.
I think this was the email that Vivian sent out.
Oh, it's the same one?
Yep.
Oh, okay.
Oh, yeah, this is what I received.
Oh, okay.
We all received.
Oh, I
it.
thought, okay, yeah, got it.
On January 10th.
Okay, I'm gonna run through these bills in a minute. I'd like to make a couple points first. The email from Ed Larkin, July 21, that Rob read, that states that the estimated total professional fees for this application would be $13,000. It wasn't an amount that initially put into escrow. That was an estimate from Ed Larkin of what the total professional fees would be on this application. $13,000. We're already over $22,000, or almost at $22,000, and we're not close to the finish line here. In fact, we're going to be further away from the finish line after the planning board rescinds the seeker negative declaration that the board issued on the prior application. It's already been approved and done with. And we're going to have to start the seeker process all over again. So it's just more delay and more time, and there's case law, which I'll provide to the judge, where that's one of the problems the courts see with these fee-shifting laws, is that it just allows boards to delay and continue to bill from their consultants.
Can I just make a clarification on that? That was not for the total?
It was.
We were looking to set escrow again at that point.
Doesn't
Because
mention
had
escrow,
completed.
doesn't mention escrow in the least in that email. Well, why don't we let Judge Foreman can make that determination?
Well, I'm curious, what's your take on that?
Yeah, because we were getting ready to reset escrow, because at this point, we had all these changes that happened, and they were proposing these changes, and we needed to
Yeah,
reset
it was
escrow.
20,000, wasn't
Originally?
it? Yeah.
Originally, it was set at something like that, at
Yeah.
the very
So,
beginning of the
it came
project.
at
and-
13 because that was.
Yeah, they got completely depleted,
He knew
so
about
at
that.
that point that he wrote this letter, we were trying to reset escrow, so we went to the consultants again and said, look, how much do we need to put in escrow at this point again? And I think that also at the time was anticipating Robert Orr's cost, which we hadn't received, a bill yet from him.
It says, we anticipate that the reasonable necessary fees associated with this application, including professional services incurred to date, is $13,000. There's nothing about an escrow deposit.
Yeah, that's what this letter was about.
Can only read the words. Okay, another important thing here, in your local law, it authorizes the village to charge back to applicants a reasonable and necessary fee, which is hard to define. But then it goes through to talk about considerations that should be included when you're determining what a reasonable and necessary fee is. And what it states is such as the size, type, and number of buildings and/or structures. Well, we're dealing with one building here. Topography of the site, it's flat, but in addition on this application, which deals just with the changes that had been made to the building, has nothing to do with the topography of the site. Environmental conditions, again, that had all been studied on the first application when they got approved. And again, what we're doing, the application we had before the planning board now is to amend that earlier approval so the board can review the changes that we proposed to bring it back more in line with the original approval. So it relates only to the aesthetics of that building, and also then, as the planning board said in one of the resolutions, that in turn relates to the community character. The other considerations, the infrastructure proposed, well, that's already been done and approved. There's no new infrastructure. And the complexity of the legal, engineering, and/or planning issues, well, it's a straightforward application, and you really even barely need consultants on this application. It's strictly a matter for the planning board to decide whether the proposals that we've made to bring it back more in line with the original approval is satisfactory to the planning board. It's not a legal issue. It's not an engineering issue. It's barely a planning issue. So those are all the things the board has to consider when setting these fees, and none of these considerations apply on this particular application. The review fees that can be charged back to an applicant are those that are limited to the review of the site plan and of the applicant's submissions. So for instance, just as an example, and we'll find more examples when we go through the bills, you know, a conference call that the architect has with the planning board where he's getting his marching orders, that can't be billed back to the applicant. That's a village charge, that's a public charge. The conference call that the architect had to talk about.
Let me ask you, let me just jump in.
Sure.
If he's only being retained on this project, in other words, he's not being retained on multiple projects, would you agree that the time he spends talking about this project is billable?
No.
Which architect are you talking about?
Or Robert Orr. No, I don't. And I'll tell you another very important reason for that. The reason that the planning board sought Mr. Orr's opinion, and it's based in the board's own resolution, is that the board said that, the planning board's resolution, is that the changes to that had been made to the building might create significant adverse impacts under the State Environmental Quality Review Act. And that can affect community character, which is also a seeker issue, the Environmental Quality Review issue. So that's why the planning board wanted to retain Mr. Orr, and you heard himself say how he went through the comprehensive plan and how this building, in his opinion, you know, the aesthetics of it is out of character with the community. It's a seeker issue. Under the state law, the state statute, the environmental conservation law, in terms of seeker review of a plan or of an application, an agency may charge a fee to an applicant in order to recover the costs incurred preparing a draft environmental impact statement or reviewing a draft environmental impact statement. That's it.
What section are you,
This is Article 8, Section 0109, subsection 7 of the Environmental Conservation Law.
What was it again?
8-0109, subsection 7. And the regulations, the seeker regulations say the same thing. That's in 617.13. Give you a subsection. A, little a. And now the seeker handbook, which is published by the state DEC, states seeker fees are intended to cover costs of scoping plus preparation or review of an EIS. Exactly what the law and the regulations say. The handbook also says that seeker fees being charged out to the applicant are not intended to cover a lead agency's conduct of the seeker process. So this advice the board may have received from their attorney about seeker procedures, and in particular, this rescission of the negative declaration, which when we go through the bills, you'll see the village's attorney spent hours and hours on end to try to justify this rescission of a negative declaration. And Dave's right, I did submit letters objecting to that, and we completely disagree about that. That's not the issue for tonight. But all that time that was spent to essentially delay the planning board process, and in fact, put it in reverse, can't be billed to the applicant. Now, the local law also requires that there be a survey of comparable fees, and as we can see, nobody has anything in writing with respect to that, which is a point also made by the courts. Okay, I think I've hit the legal points, and if I may, Judge, I'd like to just summarize these in writing to you when I get an opportunity within the next couple of days.
And I'd like an opportunity to respond.
Absolutely.
Well, why don't we make simultaneous submissions? I don't think it's fair to have one attorney respond to the other.
I generally, in my, in this work, ask both parties to submit at the same time.
Okay, that's what I would suggest.
But I ask that they copy each other.
Yeah, of course.
But that I don't get into replies, insert replies and things like that.
Right, okay,
So,
that's fine.
If we, before we leave tonight, we work out a date that works for both of you, I'll say 5 PM that day.
But Judge, you know, this is his issue. I want to be clear as to what, I was taking notes, but I'd like to know, you know, he should frame the issues, so I'm not responding to, or if I'm not, I don't want to not respond to one of his issues, so this is being raised by him, so we're gonna.
But he's framing it tonight though, right?
Well, verbally, you
Right.
know, and I just want to make sure that it's.
Well, let me ask you this, then, what is your objection to him seeing yours and what would be your objection to that?
Yeah, and if you want to have a reply, it just doesn't make sense to have, in this context, not to see what your arguments are and then respond. We can do another round if that.
What are your thoughts?
Yeah.
Well, I just don't want to have the opportunity for, for Dave's reply to, not be accurate, not comply with the law.
Well, look, I have to compare whatever anyone has submitted to the law and make that threshold decision before I write a recommendation to the board. That's really my job. If I were to give you the ability, I'll take back what I said 5 minutes ago. If I let you submit first, Dave responds, and you reply, does that seem fair to you?
That's fine.
Okay.
That's fine.
Could I ask Ben just a quick question? Did you say Mr. Orr's part of his report was based on seeker, so it shouldn't be
Yes.
billable in that respect? Because 9865, part of our site plan review, G12 is compatibility of building design with the existing characteristics of the neighborhood. So, I mean, his review completely falls within our site plan review, not just the seeker part of the review.
All the issues do. I mean, that's the conformity, and so it's, again, let's not talk about that anymore tonight. Let's let him put it and see what his issues are. We'll respond and we'll take it from there.
Go ahead, Ben.
Yep, I'm just making a note.
Sure.
Okay, so I'd like to run through these bills, if I may.
I'm just gonna start, if I could just a procedural thing. If we get into, if he's gonna be questioning my bills, I'm anticipating some of these things may trigger attorney-client privilege. So we may need a privilege log or something like that if there's an issue on that.
Okay. I don't think I'm really gonna be asking for any elaboration.
Okay.
I think you live or die with your bills for that
Okay.
matter.
All right. That's fine.
I object to the testimony tonight. We were charged these bills after the fact. We hear firsthand. from the planner and the architect seeking to justify their bills. So I don't think that's
So you don't
appropriate.
plan on asking any questions about the bill? You don't really wanna know answers, you just wanna
No,
challenge it?
I think, yeah, I think on their face.
You're not gonna,
I think
I
these
disagree
bills,
with it.
I think these bills on their face cannot be charged back to an applicant.
Well, that's, you may have a little.
Then you have the floor.
Yeah.
Okay. So the third page in is, well, let's start with the second page in, that's Labella's bill. And actually, I have no objection to the rate that Labella charges, and their fees also were, the least objectionable. And when we get through it, I'll point out the reasons why, the objections that I do have. I just want to point out on this first Labella bill, the one that's dated at the top, October 31, 2022. Karen put in 6.5 hours. She did produce a report in November, so I'm assuming that report was the result of the 6.5 hours. Although the bill itself doesn't tell you at all what was done during those 6.5 hours, which to me is just an incredibly long time to review a site plan and an application, particularly on a project that she was already familiar with from before, that had already been approved. And the only difference now between this application, what was all previously approved, was the building aesthetics are different and have to be reviewed by the planning board again. That's the entire purpose of the application we have before the planning board now. The next item is the law firm's bill, statement as of 10/26, where the first entry is September 12th.
That would be page 3.
Yeah, are they numbered?
They're not.
Yeah,
but
okay.
I'm just going sequentially, it's the
Right,
next
yes,
page in your
yes,
packet.
it is, that's the third page. So, here we have the first entry, telephone conference with R. Pfister and meeting with R. Pfister. It doesn't say what about. It lasted an hour, apparently. Now, keep in mind that all of the fees that get charged back to the applicant must be reasonable and necessary. If it doesn't tell you what the subject of that call was,
I'm sorry, Ben.
how can it possibly be reasonable and necessary?
Which call? I'm sorry, Ben.
9/12.
September 12th, 2022.
Is on my bill?
Third page in, yeah.
It's actually, I think that's Lusardi.
That is, but it's the same law firm.
Right. And the heading of the bill is 146 East.
Oh, yeah, no questions about this project.
Okay.
But what's the subject of it? How can it be reasonable and necessary
Well, this gets into the.
if you have no
very-
idea what it is?
This gets into the very issue I was just mentioning. I mean, there are a lot of issues associated with this project, given that we're in the middle of litigation, so we're not gonna, necessarily be able to tell you exactly what went on without waiving privilege. So-
Well, if it pertains to the litigation, clearly that's not relevant to this particular application and can't be charged to the applicant.
It wouldn't be pertaining to the litigation. We are in litigation though, and it's, the process that we're following and, how it, I mean, part of this is, the court ordered you to stop. And it's, that puts us in an unusual light. So
The
there's a
court
lot of-
order,
Instead of you guys going back and forth,
Yeah,
we'll be here
sure.
till
Yeah,
midnight.
sure.
I understand your position. You think it's too long, too much time, and
not only that, it's,
More
what's it about?
information.
it's not detailed enough.
Not in the least.
Okay.
How can it be reasonable and necessary? You had a
Why
call
don't
with the
you-
chairman, and a meeting with the chairman.
Why don't you proceed?
Okay. Next item, prepare outline for planning board meeting. Point 8, what's that? That's like 50 minutes to prepare an outline. What about? Next one, email with, this is between attorneys in the same office now.
This is McElhaney to Daniels.
To Dave, right. So we got two attorneys in the same office sending emails to each other and then billing the applicant for their email exchange.
So you don't send emails with your colleagues?
Of course I do. I don't bill the applicant.
You don't bill your client for emails? Are you kidding me?
If I'm exchanging
I'd love to see
emails
your
on a
bills,
matter,
Love to see your bills.
if I'm exchanging emails on a matter, it's usually half charge each.
No,
He's not saying that you're not charging the village, he's saying that we shouldn't be paying that.
We are
That's your
hired.
client. They
We're
hired
hired,
you.
we're hired by the village.
sorry, I shouldn't-
We would not be,
No,
we would not be doing anything. I mean, this is all generated by, unfortunately, in this case, the applicant violating the site plan and having to come back in. And it's, you know, it's not something that we would like to be doing, other than the fact that you're here trying to get an approval.
As
And
I
we're
said
working
earlier,
on trying to,
as I said earlier, and as
I
Diana
just
just
think
said,
this is getting to a point where it is, like Robert Orr said, it's close to harassment.
We're not-
And again,
oh, God.
it is.
we're not
So-
saying that these
but
aren't
it-
legit.
Ben, it's just such, it's.
We aren't saying that these are not legitimate charges to
Yeah,
the village.
But the
Not
thing is
necessarily.
that you're.
All we're saying is they're not
You never let
legitimate
us-
All right,
charges.
I'm gonna jump in.
Okay.
All right, I understand your point. What I did notice is that there's no duplicate time. In other words, Daniels is not billing anyone for his time in reviewing that email. Sometimes, what I've heard in the past is that there's objections that when two lawyers in the same firm are consulting with each other, and both lawyers send a bill for their respective time, there's I think a legitimate complaint that why, the fact that somebody's sending you within the firm an email about what they've come up with, say on legal research, and then you review that email, and now you're both sending a bill to the client, it seems duplicitous. This is not that case, right?
Look at the next two entries, September 27th. Same phone call.
Well, 2 weeks later.
Right, but same phone call. Daniel's on the call, Lusardi on the call. RCL on the call, that's, I don't know who that is.
RCL is Robert, he has.
Oh, that's
Yeah,
Lusardi, right.
there were 3 attorneys on the call, we billed for 2. So,
And the call happened to last an hour and,
I see what you're saying.
what, 20 minutes.
Gotcha.
I mean, who talks on the phone that long?
oh my goodness,
Seriously.
I mean, you.
All right, let's
Yeah.
not have the,
The last entry is, I think Dave acknowledged this before, is not on this application.
That was a mistake.
Okay.
on 929?
Yep.
Yeah.
Okay.
All right, same with the next page, which is the statement as of November 27, 2022. You review an email concerning notice of seeker. That's not permitted to be charged to the applicant. Only the review of an environmental impact statement or preparation may be charged to an applicant concerning seeker.
Well, let me ask you this, I'm gonna kind of cut to the chase a little bit. There seems to be a divergence of professional opinion between both of you as to the applicability of the law that allows the chargeback to an applicant for legal work done in preparation or done in conjunction with that application versus what seeker allows you to charge back. Is that, am I accurate in describing the dichotomy?
Well, with respect to
You're focusing on seeker.
No, not entirely, but a lot of these relate to seeker. And later on, we'll see it that a lot of time was put in on this issue of rescinding the negative declaration under seeker.
Well, that hasn't, we're not at that point, right?
When you review these bills, there are hours and hours put in on legal research and writing and resolutions on that precise issue. On that
Okay.
precise issue. And again, with respect to that, it's not just what the statute says, that you can't charge for seeker fees.
We're gonna brief this. I mean, this is, you're gonna.
I think it's
you're gonna
important for
sub-
the board to hear it as well.
No, I don't. I think, let's because, this is an
I
issue
do.
you didn't.
I do.
I know, but
It's
you
my
didn't-
client's appeal.
I understand that, but this is the hearing officer, and you are coming up with some, you didn't raise this issue before. and you didn't.
When before?
Before this hearing. So you.
That's the whole point of the hearing is
I
to raise
know
the
it, but
issues.
if you should have expected that I would wanna respond to the legal issue, and you're blindsiding me, and I'd just like to have an opportunity to respond,
Okay.
so.
On October 11, we have a conference with the chair and prepare resolution regarding neg deck. That's the resolution to rescind the negative declaration on the prior approved application.
Okay.
Research seeker, that's the research whether there's authority to rescind a negative declaration. Next entry, prepare for and attend planning board meeting. 3.5 hours. I was at that meeting. We were on for maybe, half an hour or so. So prepare for and attend for 3.5 hours. On that same day, this is a paralegal in Dave's office. Conference with DED, proofread the planning board resolution, email resolutions.
You don't have paralegals?
Don't charge for them.
Oh, okay, love to see that.
Going back to October 11th.
Yep.
Your position is the 3.5 is an embellishment of the actual time spent at the planning board meeting on your client's application.
Absolutely.
Yeah, it's completely offensive.
Absolutely.
And
I'm not trying to be offensive.
Well, it's just
come on,
it's just-
it's common sense.
You.
What takes 3.5 hours to prepare for and attend a planning board meeting? The meeting itself was half an hour, with regard to my applicant. What are you preparing for 3 hours? Please.
There's a lot of issues here. A lot of.
No, there's not. The
So
only
what?
issue on this date was rescission of the seeker negative declaration.
That's not true.
Take a look at the entry of the fourth entry on this page for October 11. LLM, law clerk. Review tasks from DED, begin reviewing prior research regarding rescinding negative declaration. That's what it's all about. That's what all this research and writing is about, rescinding the negative declaration.
I don't disagree with that.
On 10/12,
That's
review
not-
notice requirements in state zoning law. How does that relate to a review of this application? Those are the sort of things, notice requirements apply on every application. You can't bill that to a particular applicant. October 13, I don't know who TEED is. But seeker concern related to water.
These were the Department of Health.
Okay. There's no issue. Sewer and water has never come up
Yes,
at
there
these
is.
meetings.
There was a notice, that there was a problem with the mayor's involvement with the water connection, and Jim Teague got involved
On the
because
first
he wasn't.
application, not on this one. It hasn't come up at all in the
He
planning
wrote the
board.
letter very recently and said, and when we notified him, he wanted to be involved because he hadn't been involved before.
All right, I'd like to see that letter if I may.
Yeah, absolutely.
And then on the rest of this page, 1013 through 1017, well, 1013, the HVAC issue has nothing to do with the review of this application. 1016 is the same thing, permission to get the heat on in the building, nothing to do with review of the application. Same with 1017. And then 1017 again, conference with chair regarding seeker issues. Next page again, 1018, 2.8 hours. Research seeker issue regarding scope of review.
Can we just, this is so repetitive, I mean, you've made your point.
Yeah, no, these bills are repetitive, and I think it's important that we all see this.
So your argument on 1018 is that it's excessive?
Excessive and it involves seeker. Then 25, Bob Lusardi had a conference call with planning board. Regarding what? How can that be a reasonable and necessary charge if it doesn't even say what it's for? By the way, for an hour and,
For purposes,
for an hour and a half.
it was legal advice, if you know what that is.
1026, research the statute, refine the letter, again, concerning the rescission of the negative declaration. The next page is one of the Robert Orr bills. This is when he attended the meeting on August 9 and charged $2,000 for doing that, plus $127.50 for mileage, including his travel time going back and forth. I don't have an objection, well, look, I do object, because it doesn't say what was done, but the next bill is the Lavella bill from September 30, 2022. Again, it's just, it doesn't, I do object to it. What was done? How can you say that's a reasonable, necessary charge, which is the requirement, the local law requirement and the court's requirement to bill back to the applicant when it doesn't even say what was done?
Is Karen still on the phone?
I don't know. Yes, she should.
Karen?
Karen, are you there?
Hey, Karen, just to,
I'm here.
do you want to just respond to that, if you heard it?
Did you hear the last discussion, Karen?
I was listening, but I didn't recognize it was for me. Ben, could you please repeat that?
Sure. I'm questioning, it's a bill that's dated September 30, 2022. It's for the time period from August 20 to September 23. You spent 2 hours doing something concerning this application. It doesn't say what, it doesn't even say what the date was. So my comment to the board is, how can that be charged back to the applicant when the bill doesn't even say what was accomplished?
I see. Well, I don't have the bill in front of me, but if it was 2 hours from August 20th to September 23rd, it most likely had to do with the submission that was made for one of the meetings, and I was reviewing it, which is my job.
And did you submit a report to the planning board for that review?
You know, there wasn't always a reason to submit a report, and it may be that part of that time was spent in talking with the chair or the attorney.
Okay, but it doesn't say that, so we really have no idea. Nobody does.
Are you,
What happened during those 2
are you,
hours?
what you telling us now, Karen, is what your typical protocol was?
Yes, so I think a submission date is something like 2 weeks before the meeting date.
Right.
So I have very little time to turn around to review, and generally speaking, I don't get to reviewing things until Wednesday, and I'm due to report back to the planning board by the end of business on Thursday. I try to make that deadline as best I can, but for very obvious reasons, with 2 weeks to perform a substantive review of something, and a quick turnaround time, I'm as efficient as I possibly can be with that time, because this is not the only board that I work for. I also am the village planner for the village of Mandan, and I work on a multitude of private development projects across the Hudson Valley, where I'm in meetings multiple times a week. This is my second meeting for this week. I had 3 meetings last week. I have 2 meetings next week. So it's not like I've got all the time in the world to just sit
Do
there
you,
and
do you
that.
generally go to the planning board
I
meetings,
do that
Karen?
being extremely efficient.
She does.
I'm sorry?
Do you generally go to the planning board meetings?
Yes.
Yes, I go to all the planning board meetings. I think I've missed one for a funeral, and I've joined them from my vacations at times. So yes.
Can I just say something?
Sure.
I think what I'm seeing here is, it's sort of, and what just happened with Karen, it's, when you're a consultant, you're a professional, there are myriad issues that come up that you deal with. You're thinking about things, you're reading something, you're hearing something, there's a detail. Ben knows all this. He's I'm sure that if his bills were in play, it would be the same thing. And can you remember, can Karen remember 2 months ago? No, but she wrote down, I did a task, and this is the time I took. And the same thing with Robert Orr, it's just any professional, you're doing the work, and there's issues, and, you know, to try to say every thought process, every issue that's considered has to be written down, and that attorneys can't consult with one another, I mean, it just, no attorney could ever get paid. You wouldn't get paid. I'm sure your bills would not stand up to scrutiny.
What I'm gonna ask is that both attorneys don't make it personal at all, talk only about the invoices that are before us.
But it is personal,
I know,
Judge.
I know.
He's talking
I'm not-
about
I'm trying
keeping
not to be-
time, and so I'm coming back to him to say, he's doing nothing different, probably not as good, because our bills are very detailed and they've survived scrutiny. I'm an arbitrator, I've reviewed legal bills and fees, and these are very appropriate, very detailed. And if I had to, I could go back and we could spend, 10 hours, it'd have to be under camera, but this is just outrageous.
Let's go
It's-
forward.
it's harassment.
Karen, thank you very much.
Sorry, but-
Ben, go ahead.
Sure. I think it's obvious to anybody that these bills are not detailed.
Are we done with Karen so she can be released?
I don't
That's a good
know.
question.
I don't know.
No, but I can jump to her
Let's
other-
take care of Karen.
Yeah, I can jump to her other items. It's the 10th page of the document. It's the next Labella bill.
That's August 31st?
Yes. That one doesn't have anybody's name on it. 3 hours were spent doing who knows what by a senior professional 3. That's not Karen, she has a different title. She's a something 4.
Who would that be, Karen? Do you remember?
I'm guessing maybe that's Ed Larkin.
It's $180 an hour.
Well, guys, sorry, I don't have everybody's billing rate
Exactly.
memorized, but I know that
Just- I
Ed
mean,
Larkin is, I'm almost 100% positive he's a senior
Oh.
professional. There's really nobody else that works on this project except me, Ed, and an occasional engineer that I asked.
His name actually appears on the bill. It says,
Confirmation that something's accurate.
Building Department Assessment.
Yeah, see, it doesn't read, and then below that it says operating permit program. This
Yeah,
has nothing at all to do
This
with.
is a mistake. This shouldn't be in here.
Okay. Anything else for Karen?
I think there's one more, yeah. Now, this last one is fine, July 31, 2022.
That one's good?
Yeah, I mean, again, it doesn't say what was done, but it's only half an hour.
Okay. So, we can let Karen go?
Nope, sorry, we got one more here. That's the last page, dated March 31, 2022. And you can see it says on there, billing related to review and meeting time for 146 EMS and meeting time related to Pawling Commons. And it doesn't show that there's any, breakout. But even if this time on here, 2.5, is only for 146 East Main Street, it says meeting time, well, review and meeting time. Again, who knows what was done, and we don't know whether some of this might involve the.
You have your bill in front of you on that one, Karen?
No, I don't. What task was that billed under?
It's,
What'd you say, what task?
What?
Like 0100?
0103.
Every 0103 is 146 East Main Street.
Yeah, that's what it says, 146 East Main.
I bill all the time specifically to this project. I can look back into that bill, and if there was a missed bill or, I typed something out wrong, I'm not sure. But I'd be happy to review it again.
I think the only thing that it says is meeting time related to Pawling Commons.
Right, yeah. I don't know whether there's a breakout someplace.
Is that a separate project?
Yeah.
It's unrelated to
Pawling Commons is a
146
separate
East Main?
project with a separate task number, so I mean, it certainly shouldn't have been billed to 0103. If it
Well-
was, it was an error.
Well, there was some discussion. It says billing related to review meeting for 146 East Main and related to Pawling Commons.
Right.
And it says right here, the 10103 is 146
Is
East
right.
Main.
Yeah.
So I think the hours are specific to 146. I'm not seeing anything specific to Paul Commons on here.
If you don't mind, Karen, if you could just go back and check that out, and if you see something that you think is an error, if you could let the mayor know.
Sure.
Does that work for you,
Yes,
Lori?
I make very prodigious notes as to most things I do on a daily basis, so I should be able to get to the bottom of it.
Thank you very much. That's it for Karen?
Yes.
Thanks,
you.
Karen.
Thank you, Karen.
Thanks, okay.
Have a good night.
Okay, so we're on the 8th page now.
And that's Daniel's bill,
Yes.
as of 9/28/22.
Yes. So the first entry on August 4, email regarding the escrow. Clearly, that's not related to review of the application.
Yeah, that shouldn't have been on there. I agree with that.
Prepare for and attend planning board meeting, 6 hours,
What are you talking about? Oh,
I'm sorry.
on August 9th.
August 9.
Okay, gotcha.
Yeah, yeah.
And attend.
Pardon me?
The what?
It's prepare for and attend planning board.
Yeah, yeah, 6 hours.
And
The planning board, none of the meetings involving
I will tell you that-
146 East, Dave, I'm speaking.
One thing at a time. Go
Yeah,
ahead.
none of the meetings involving 146 East Main Street took more than, half hour, 45 minutes. I mean, we're talking about 5 hours of prep on one application.
Dave?
I
What
remember
was
this I do remember, and it was involved with reviewing the master plan, which I was very involved in. The issues here that Ben gives very short shrift to about conformity with the master plan, community character, there's a lot there. And, this whole project and the issue, a big part of it comes down to promises that were made by the applicant to the planning board and the ZBA, promises that were broken, and leading to the need to litigate, and now you're coming back to try to fix it. And it's not a simple issue. There's because there's issues of what, the community character and conformity of the master plan. To identify that, you need to look at the master plan.
All these meetings are taking in the context of litigation.
No, it's not in the
I mean,
context.
litigation preceded these planning board meetings.
Oh, yeah, well, there was litigation, but what I'm talking about is they're coming in, and there's nothing wrong with them coming in to try to modify and get an approval of the application. But the issue that's before the planning board is conformity with community character and the comprehensive plan, visual aesthetics, which is a big part of our plan. We have a very special comprehensive plan, and it's somewhat unique, which again presents additional complexity of the legal. So I remember preparing a ton of stuff, listing, and I have it. And I'd be happy to share it with you. I've got pages and pages of my notes digesting the comprehensive plan, analyzing the context of this project, the gateway to the community, the residential character that was promised that wasn't delivered on, and you can go on and on and on, and that's what this is involved, and he wants you to think that this is a nothing, oh, come on and just give us come on, we made a mistake, give us an approval, and it's not that simple.
And is it your recollection?
Hang on.
Is your recollection, hold on a second.
No, I'm talking now.
Is your recollection of how long the actual applicant was before the planning board, is that?
I don't remember. I mean, some of the meetings seem to go on a lot longer than that.
Just for the applicant, just for this?
I don't know, yeah, I can't remember, honestly, but I do remember that there was a lot of preparation, and, there's this kind of discussion going on, and we need to be ready with the issues, because we're discussing very important issues.
There's one issue
So-
before the planning board.
No, that's not true.
There's one issue.
Go ahead, Ben.
Are the proposed changes proposed by the applicant to bring this building back close to what had been approved? That's the only issue before the planning board. You don't need a lawyer for that, you don't need an engineer, you don't need an architect for that. It's really up to the planning board.
Well, that's really
to
up
make
to the,
that
but
decision.
would you agree that's the planning board's determination as to whether they feel they need counsel?
And that's exactly what the cases say on these chargeback, that it just gives boards too much discretion to hire whoever they want, take however long they want, because they're just gonna bill the applicant. And the courts reject those. The courts don't allow that. And that's exactly what seems to be going on here. I'm not saying intentionally, but that's the effect of
Yeah,
this.
that's,
Okay, look, let's keep moving forward.
Okay. Same comments on 8, 16, and 17, conference with the planning board chair. One for 25 minutes, one for 15 minutes, what about
come on.
829 on that page?
Why do we have to?
Let's move
come on,
forward.
10.25, you gotta be kidding me.
Let's move forward.
829 on that page. It's
Judge,
all
I would
about,
ask you to cut this off.
It's all about
I just don't
seeker.
see what, it's all repetitive. You got something new, you've raised the issues, you're
No,
basically
no,
making the
not-
point that, let me just finish. You're making the point that wherever there, you don't know what the conversation was about or what the cast was about, that you can't bill it. That's an issue, I think that's an issue that the board can deal with. And, it's not going through line by line and you're repeating yourself about everything that's.
No, I'm just reading these entries. I'm not
Well,
the one repeating myself.
I think in the interest of time, you're gonna be able to submit something in writing, to me. And I would, assume that you're gonna do the detail that you're basically giving us, tonight at this hearing. Is there a different topic or something that hasn't been discussed that you wanted to draw the board's attention to? In other words, there's gonna be 4 or 5 more of these bills from Daniels that I assume in your writing to me, you're gonna say, hey, same problem, excessive as far as preparation time, for the inter-office,
Yep.
But is there another area that you haven't had a chance to bring to the board's attention that you think would be appropriate for them to at least hear correctly before we conclude the hearing?
I don't think so.
They're all the same?
Well, if you go through these bills, they're all gonna be the same. It's gonna be
The same.
excessive time, seeker review, which isn't authorized by the state statute, and the inter-office dealings where we're getting charged by more than one attorney.
Okay. But you can lay those out in black and white.
And I will say, if that had been brought to my attention before this, I would have said, absolutely, write it off. It happens, things come through, and like I said at the beginning, so those, I don't think we should waste any time on that.
Okay.
If there's a double up on an attorney or whatever, if it's legitimate, you're working, you're doing, but it is, I have no problem with, those entries.
Can you lay out those ones that you, if you
Yeah.
wanna say consent to,
I
in
think
your
that- I
writing?
think Ben has
Okay.
already, so.
You wanna talk about a schedule? Timetable to get?
Can I say something?
Absolutely, you're the applicant.
I know, I never asked you
Oh.
first.
No, that's fine. I know what you want to say.
I just want to give some background information. My name is Diana Tomasetti. I am one of the owners of Main Corner Properties, which is the restaurant.
Right.
We are not long-time residents. We've been here in Pawling for quite some time. I don't know if you're aware that we are developers. So we developed Riley's Garage, and whether or not people like the building, it is certainly an improvement. And we've also purchased 4 or 5 other buildings up on East Main Street, and right now there are 7 thriving businesses there. And East Main Street looks much different than it did before we started renovating. We also purchased Joe Patrica Inc., the plastic factory, 4 years ago. And so I am one of the largest employers in Pawling, and I'm also one of the highest taxpayers in the village of Pawling. And we have many at public events, on our public property, at our own risk, and we do it for the enjoyment of the community. I love Pawling, I love this village, I really do. With all that being said, I'm not asking for special treatment because of that, but I will tell you, the construction of this one project got out of hand. We made a lot of mistakes, and in hindsight, it was the height of COVID, there was supply chain issues. In hindsight, of course, I would have done everything differently. But we didn't, and here we are. But I think out of the $70,000 that I've paid between permits and escrow, $30,000 has been after they rescinded my permit. So my thing is that we haven't been able to do any work. And Mr. Orr, the biggest disappointment about that $10,000 was that he didn't make a suggestion on what we should do to make it better. I thought that's what he was hired for. All he did was look at what we originally said we were gonna do, take pictures of what was there, and point out every single difference. We already knew that. But we were looking for some sort of guidance on what it would look like. And in this whole year, and all this time, back and forth to the planning board, we submitted what we can really paint it and make changes that it will look very close to the original rendering. And they will not sit down and talk to us. I don't even know what it is. I know what they're offended by, but what would it take to appease them? And now, to rescind the neg deck, if you're gonna rescind the neg deck and think that we're gonna file all over again and go through this, it's gonna take a whole year to go through that process again, to be in the same exact position that we are right now, with an empty building that's not finished, and nobody will tell us what color you want the roof to be. Or what can we do? So I feel, as community members, I think we deserve the right to sit down at the table and speak about this. Not all this legal, everything's legal. I don't know why you're so hell-bent on taking back the neg deck, which the community wants the restaurant open. It's not even just me. You're not hurting just me. So I ask you, please, before the next planning board meeting, let's sit down and talk. Tell us what's acceptable. We're willing to do just about anything. We made a grave mistake, but it was not intentional, and you could see that we don't do shady work. It's very well built. The size of the building hasn't changed. Nothing environmentally has changed. The only thing that's changed is the color. So the color of the brick, the color of the hardyboard, and the color of the roof. We can paint them all. And we do not have to go back to court. When we hung up our Zoom call with Judge Gillespie, she said, I hope you guys can come to a conclusion by yourselves. So we don't need a lawyer. We need the planning board to sit down with our architect, if you want to get another architect, and see what we can do. Because I'm not going to do this in a whole nother year. I'm not going to pay another $50,000 to be in the same place next year, still trying to figure out what you want to do with that building. It could stay there another year. Or 10. I mean, I don't think it's unreasonable that I'm asking to sit down and talk about it and stop all this legal litigation. Thank you.
Thank you. Give me a timeline that works for you, Ben.
I know you had told the board that you have a report in 10 days, but I think that's gonna have to be, put off a bit.
I didn't anticipate
Yeah.
writings,
Right.
so I'm gonna push that back to, you tell me when you wanna submit. I'll ask Dave what his timeline is, and I'll go from there. But I'm not gonna sit on this. I'm gonna try and get something
Sure,
done properly.
sure. Yeah, I think, just with my schedule, I'd like to have till next Tuesday.
Which would be today's the 17th? 24th? Dave?
I'm gonna need a little more time. up to my eyeballs. I was out most of last month, and I've got 2 appeals that I've got to get done.
Give me a time.
Probably 3 weeks after that.
So that would be the, actually brought my calendar. Here you go. Don't laugh, because I have a paper calendar. Let me ask you this, given how much time Dave needs, would you wanna go 2 weeks out as opposed to 1?
Sure, just to make sure I beat the deadline, that's fine.
Do you wanna do, the 31st?
Okay.
Ben?
What I'd like to do, though, if I may, though, is if I do submit early, that they would get 3 weeks from the submission date.
I'm just gonna give him the date now. I'm gonna give you the 31st.
Mhm.
Dave, February 14th?
Yeah.
Is that good?
Yep.
And then Ben, I'll give you a week if you wanna get any kind of a reply in.
Okay.
All right, that'd be 21st. Any questions from anyone on the board?
I'm guessing the end of February for your report then, or?
Yeah, so if I get everything by the 21st, I will. I'm gonna get you a report by March 3rd. Does that work? Any questions?
No, I'm good.
None here. Okay. So Mayor, I think that concludes the hearing.
Thank you very much.
Thank you.
Thank you.
Thank you all very much.
Thank you, good night.
Good night.
All right, can I have a motion to adjourn the meeting and go into executive session?
So moved.
All in favor, say aye.
Aye.
Good night, everybody.
Good night. Good night. Nice meeting you. Thank you.
Nice to meet you all. Yep,
Sorry.
take care.
Failed to say executive session for litigation.
Thank you, Pete.
Take care, Ben. Nice to see you again.
Good night.
Everybody leaves, you can stay here.
So.
No, we can't, John.
Hours for
Because it's
violation.
wrong.
Consider.
We do that every time.
But he's thinking, Phil, and he.
So we could, we could go after it. Just compare apples.
That doesn't have that.
With that,
Punished. We have.
Well, as we were going through that whole process.
So here's the thing. We don't have to, the village will put that all on hold.
Peter, nice meeting you.
Take care, nice to meet
So
you.
that they can-
Dan, take care.
Normally,
Right, John.
have fun upstairs. Your penalties would start running and, but.
Hey, Judge, Lou Michelle, I'm on the planning board as well.
Hi, Peter Foreman.
But as
Good job,
part of
Judge.
working through those
That's right.
amendments in time, we might spend
It's a
talking
difficult
with,
situation.
I might spend.
That was a
time
piece
with
of cake
Karen
for you.
or yourself.
I served in
Don't make it look so
I
hard.
served in family court for 10 years.
Because there was these
But
violations.
that's the ultimate emotional,
Oh, I bet it is.
you know?
Oh, my
God.
I gotta use that bedroom.
Yeah, it's upstairs, Judge.
Upstairs?
That's upstairs.
I can leave my stuff here?
Yeah, sure, that.
It's like you're in a punching bag as you're sitting here. I mean,
I think it's the second door on your left, Judge.
Okay, thank you very much.
Well, I'm not talking about golf.
Good job.
I have to talk to you guys, I wish I was.
Not as bad as
job,
I
Rob.
expected, believe it or not.
Dave?
You wanna, yeah?
Think so.
You wanna go down to the Legion Hall down there and have one?
Sure, why, they're open to anybody?
Yeah, anybody can go in there.
Yeah, why not?
I hope they should be open. Want me to drive you down?
Oh, I'll meet you down there.
All right, I'll meet you down there. That'd be good.
Let's change the scenery.
Yeah. It should be open. It'd be nice.
accidental, or is it gonna?
Not really. Give it a little short run.
Very distinguished.
Tried to give you one.
Okay, no decisions were made in executive decision, no votes or any kind. Can I have a motion to close executive session?
I'll make that motion.
Second?
Second.
All in favor, say aye.
Aye.
Can I have a motion to open the regular meeting back up?
So moved.
Second.
All in favor, say aye.
Aye.
Can I have a motion to close this meeting?
So moved. Second.
All in favor, say aye.
Aye.
Good night, everyone.
What'd you do, Laura?
My thumbs are split.
Oh, yeah, I get that.
Good idea.
Liquid skin.